Ladies and gentlemen, we'll put our hands together and welcome Mr. Lawyer Yaw Oppong, as I've introduced him already.
Well, thank you very much. I must say that I'm a bit upset. I'm not angry, but watching these documentaries have really pinched my nerves. And before I continue, I want us to show appreciation to IMANI because I think this is about the third time that I have had the opportunity to attend such programs, and I've always left the programs a better person because it makes you really acknowledge the deep seated poverty and lack of amenities that we, those in Accra, who hardly travel to our homes, mainly because our grandmothers are witches who swallow us, even when our bones are now hard, when they didn't do so when we were little. So we don't even go to our homes, meaning where we actually hailed from, as it were. So when you get an organization like IMANI to come out with these very important, significant documentaries, I think we need to really commend them. Now, I heard a lot about the fact that progress has been made, especially in the New Land Act. And I started asking questions of myself. Have we been able to bring these very significant, innovative provisions to the attention of those they are to serve? I mean, if I ask you whether you have ever seen the Land Act before, if we are truthful, I'm sure only a handful, if you are lucky, will acknowledge that we have ever seen the Land Act that came into effect December 2020. But that is the law that now regulates all our affairs as far as land acquisition and ownership and management is concerned. And it's very sad that perhaps even here, if we were to talk about scandals, but an individual cheating on his wife and a so-called, what do they call them? Slave queen, suing that person for about a week, we will all be captivated by that story and even forget that majority of our people are rather suffering. Instead of concentrating on these bigger matters, mundane issues, we rather get captured by matters. Now, I was even making notes about even the role of TikTok. I mean, that's where people use it to propagate such significant developments and concerns like this. Unfortunately, with all due respect, it's rather majority of those who engage in matters that I believe are not edifying our women. I mean, these days they mention things which we the men find it very difficult to say on TikTok, but majority of our women are rather suffering, and we have such an effective tool, very potent for dissemination of information. And I think that, in my view, we are just abusing it on matters that don't edify us at all. But going to the background, I had opportunity to do some notes for a gathering sometime. And I was looking at this whole background to the seeming dichotomy, as it were, in terms of acquisition of land between males and females or women and men. And I was surprised to go to the Bible, and I've titled that part "In the Days of Adam." We are talking about why is it that women don't generally acquire land, and even when they acquire, you'll be surprised to know that they rather will make it look like it rather belongs to their husband. And so in Tree we say that Oba tutua etrobema them. So when a woman buys a gun, she rather gives it to the husband to keep it on her behalf. And it's not just a gun. After all, a gun is also a property. But we are talking more about land and landed property. And these are documented. And then, as wicked as some men too may be, and they will ask you to prove that you actually acquired it. But we'll come to that. So, in the days of Adam, we know that after they have committed or they have violated God's rule, original rule, which you all know, God rendered punishment. And for the women, he said, you sweat, you will be pregnant for about 9 months if you are lucky or more, and you go through travails, pain, before you give birth to the child. And for the man, you till the land and sweat before you get food to eat. Mind you, before Eve was created, God had already created the earth and all that, the fruits that we had, and Adam had already named them. It's as if Adam has been made the owner of the land even before Eve was created. And so that is what I see to be the beginning of acquisition of land and male domination of such endeavor. And so when you look at it that way, and these have been part of some doctrines in some religions, that the woman cannot be seen to lay claim to land by herself. Now, when you come to custom, some areas, for some reason, have done quite better. The predominantly matrilineal systems, because they trace their heritage or inheritance and related matters to the female line. There have been a conscious effort in that regard for females to acquire land or land to be inherited by them. And so there's not so much, or there hasn't been so much of a problem, and these are quite documented. And I would like that maybe in future we'll do something in some of these areas and compare it to what we have seen today, which in my view generally predominantly patrilineal system of inheritance or succession. But the proverb I just stated, Sobato to Echubema them, it also permeates through even the matrilineal systems. And that led even a number of judges to also rule that when a man marries a woman, it is the duty of the woman and the children to help the man to acquire property. And that property becomes the sole property of the man and not the joint property of the man and the children. But it is rather the man's duty to maintain them in their station in life. And this is a famous case called Cote and Mate. I won't bore you too much with the cases, but it's a very famous case. And that sought to render the essence of customary law in relation to land acquisition in particular. Even though there have been some variation to that, it led to even the courts to further develop a concept called equality is equity, which is later. But before then, until you can, as a married woman in particular, show during divorce that you also own part of a particular property, even the matrimonial home, you had to show substantial financial contribution and not just any contribution. And where in one case the man was informed by the wife, I work at the ministries, I've been offered a property, I think it was state housing or so, and the woman uses her salary to pay for it. Eventually, she just transferred it into the man's name. And during divorce, then the man said, show me that this house belongs to you. I was very sad. And there have been instances where the husband will say, okay, I'll use my money to build a house, use yours for chop money. For me, I say that is a grievous sin, because God didn't create it that way. If you're a man, your duty is to work, acquire property, maintain your wife and children, and let them use their money to also keep themselves beautiful for you. You don't agree with me. Anyway, that's just by the way. So, customary law has also permeated through even decisions of the court until just recently, well, relatively recently, the Supreme Court had to break the ice, as it were, and they made some profound declarations in a number of cases, which will be sharing. But it is rather sad to say that in the Constitution, Article 22, forgive me, but we may have to be touching on some of the laws. I think, after all, they say I'm a lawyer, isn't it? Article 22, Clause 2, makes it very clear that as soon as practicable, upon the coming into force of the Constitution, which was 7th January 1993, Parliament shall pass a law that would ensure that the rules and laws on land acquisition, especially between males and females, was consolidated and enacted, that they should pass a legislation as soon as practicable to address these inequalities. I checked very recently. That law has not been passed. And we are 30 years now. Last January 7th was 30 years. I don't think 30 years we can say we are so expecting soon to come. So, but we are aware that the bill had been presented sometime in 2010 or so. But Parliament has yet to pass that very significant law. In fact, it's a duty imposed on Parliament by the Constitution itself, which is our supreme law. It's rather sad, in my view, that we are yet to see a specific legislation in compliance with this burden that the Constitution and the framers of the Constitution have imposed on Parliament. If that had been passed, perhaps, and with a significant number in Parliament relatively to men, perhaps proper legislation and provisions would have been inserted in it by our females, progressive females in particular in Parliament, who have been at the forefront of the fight for equality, of course, with some men as well. And I think that it's rather sad that it took the Supreme Court to rather say that in the case of Mensa and Mensa, the Supreme Court said specifically that they would not wait for Parliament to pass the law because it had been long enough. And they had to introduce the concept of equality is equity. But I still come to the final point that how many are even aware of these cases or the contents in these cases? It should take IMANI and a few of us, as we are doing now, to try and reach out to our friends that these are still part of our laws, which we need to access. But even for those for whose benefit the laws are made, are they interested? I mean, if we were here talking about politics, real political acrimony, sorry, I should say, I'm sure about 50,000 or 100,000 may be following us if we were on Facebook. And this room would have been full. But here we are. I wonder how many people will even want to listen, because it doesn't tackle them. And that is the state of affairs that we have now. That if we become aware of these laws, for example, if we know that the Constitution has imposed this duty on Parliament, and for 30 years, a law that is one of the few, if there's any other at all, laws that the Constitution specifically said it should be passed as soon as practicable. And it is sad, and I think I'm right to highlight it, that we are not also present as those for whose benefit the law is made. So we should ask our members of Parliament that, yes, we appreciate that there are very significant and important laws that are being made. But what about this? You have the Lands Commission Act is one of the acts that the Constitution says should be passed, and a few others. As things stand now, one of the most important laws on the rights of women in particular, widows, I should say, is the old PNDC Law 111. That is predominantly the law that regulates these areas, in addition to a few that have now found themselves in other general laws like the Land Act. But significantly, it's still a good old PNDC Law 111 and some few amendments that have been made. And yet, we should acknowledge that one, the law was made during a military rule, and so there was no parliament to have even had the benefit of broad consensus. I mean, at the time, we couldn't have even been discussing some of these matters at will. We may not even want to be on radio or be heard. So why the law that was passed in 1983 is still the law that is regulating us when the Constitution and the framers found a need for us to amend them, it still bothers me. So that progress has been made, is no doubt at all. Then we commend Parliament. For example, now, if property is jointly owned by spouses, one person cannot use it for a mortgage without the consent of the other. So you cannot just go to the bank. In fact, even more significantly, if you go to the Lands Commission to register any interest in land now, you will first have to declare whether you are married or not. And if you are married, then the property is deemed to be jointly acquired, whether or not you specifically say that it was acquired by the two of you jointly. There's a presumption, as they put it, of joint acquisition. Then also, if you were to dispose of it, if you want to sell it, and you are married, because of the presumption that the land was acquired, once it was acquired during the subsistence of the marriage, then it is jointly owned by both the spouses. You cannot, without the consent of the other spouse, dispose of the land, unless you can show that there is an agreement between you and your spouse that this house belongs to me alone, and therefore I have the right to dispose of it solely without the need for your consent. If you are not able to show that, then the presumption of joint acquisition is not rebutted. So if we put all this together, we have done very well, at least on paper. But as for the dissemination of it and the operationalization of it, we are still way below 10% in my parochial assessment, as it were. Because as I said, but for today, I would have been content that, well, there have been substantial improvement across the country. But this is a large sector or enclave of the country that is still reeling under these harsh, discriminatory conditions when it comes to acquisition of land. So I think in addition to events like this, we should go out and also engage in serious propagation of these matters. The word propaganda may be too politically incorrect, so propagation or dissemination, I think, will be better. You may encounter a situation where it can easily turn into politics. Oh, but then who did this? Perhaps who brought the Land Act? And that ends the social aspect of it. But we have to persevere because we cannot continue like this forever. Then also, there are some other key matters that I think I have had problems with. Our land tenure system has had serious challenges. Unfortunately, the Land Act in particular, in some instances, in my view, didn't address it. Perhaps it was founded on different principles that I don't personally share, in my view. So why should we say that an investor who has a lot of money legitimately wants to acquire land in Ghana, for example, for maybe coconut plantation or sugarcane plantation, should only be entitled to 50 years. Who in his right mind will go to other investors that I'm going to engage in large-scale plantation? And I hear the Ivorians are doing very well when it comes to large-scale plantation, because they are not inhibited by these, for me, needless, with all due respect, limitations. And those who have cared to talk to some even investors in other countries like Dubai, I mean, foreigners have freehold. And so he knows that when he invests in the land for at least more than 70 years, it's potentially forever, his investment is going to yield resources. So if you say that the Ghanaian can acquire land for 99 years, but a non-citizen cannot acquire land for more than 50 years at any one time, is there any research that shows that the Ghanaian is more disposed to protecting our lands better than the person who has invested huge sums of money in it? So if we want to also attract investment, and what we are talking about now is not so much about the peasant farming that we do, which is now important, but we should be looking more at this large-scale farming. And from my research, large numbers of women, in particular in Ivory Coast, have benefited immensely from these huge plantations, which we are not getting the benefits mainly because, in my view, the taxation system, and more importantly, the inhibition in terms of the years or the term of the acquisition. Because if he acquires it and by the end of the 50 years, he stands the risk of not obtaining a renewal unless the law permits, then what is the point? And that is also, for me, one of the reasons why we haven't been able to engage in this large-scale plantation. Okay. That is what will benefit our mothers and our sisters and the entire country. I'm grateful at this point. Thank you for listening.
Thank you very much, lawyer, for that preliminary one. Now, one that I would want you to touch on very briefly will be the area of developing the land after the acquisition. So we don't just want to acquire and have access to it, have non-discriminatory access to it. But after that, how do we ensure that it's sustainable by empowering them to develop it? What would be your suggestion on that?
I will still go back to the plantation system. You see, so it's possible for people to acquire the land in bits and pool them together and then form a cooperative. I mean, most banks will be more comfortable in dealing with cooperatives than with my poor old mother who has 1 acre of cocoa and so on. So that is something that I think is also lacking at almost every sphere of life. We like individual owned properties and ventures. So you don't get big law firms, media houses. We don't like to pool resources and manage it. But traditionally, we have been adherents of the true communism practice, where people will do Noboa in the village. Yeah. The next day we go to the other person's farm. For some reason, we have stopped. And now it's no more about this is ours. It's about it's mine. Okay. And you cannot attract the needed investment, which is so critical, unless you are able to pool resources together. I have a 15-acre land, farm, palm plantation, coconut, and cocoa, and other cash crops. But I have realized that that is not even enough. Okay. Thank you.